Thank you for joining me today to talk about what makes a will a will. Remember, it's about legal literacy, not legal advice. So don't worry, you're not going to be getting an invoice. I'm Simon Jenga and welcome to Simon Says. So today we're going to be unpacking what is a will. What is that term that we are referring to when we say the word will? Up front, I want to cover off a couple of pieces of legislation. So the first is the Wills Act 2007. And that act governs what is a will and what makes it valid. So that's going to be critical for our discussion today. The second piece of legislation is the Administration Act. And that's a piece of legislation that really covers what is required to administer an estate once you have a valid will confirmed. So we're not going to be dealing with that today. We're just going to be addressing the Wills Act. And most importantly, we're going to be looking at what is a will and what makes it valid. So going to that first question, what is a will? Now, a will is any document that records a person's disposition or them gifting assets that they either have or will have to people or entities. It's also a document that could be appointing a testamentary guardian for infant children. And when I say infant children, I mean any child that's under the age of 18. So those are the two things that really can constitute a will. It's either giving away assets and it's appointing a testamentary guardian. Now, when I used the word document a second ago to describe a will, immediately we default to that it must be a piece of paper. It must be something that we've written down on A4, been printed out, and then we've signed at the bottom. But that's not actually the case. So document is anything that has written words on it that is outlining those dispositions of property or the appointment of a testamentary guardian. It could be on toilet paper. It could be on a rock. We've seen stranger things. So it can be anything, but ordinarily we're going to see it on a piece of paper because that's how, as professionals, we would draft your wills, and we would encourage you to make sure that you have your proper will completed correctly in the correct format, and the easiest way to assure that is on paper in the correct format. So that basic parameters for a will is relatively simple, which means that we can turn immediately to what makes that will valid. Now, the Act is very clear on what makes a valid will. It has to be signed by the will maker. And just to kind of digress a little bit, when I say will maker, obviously that's the person signing the will. A term you might hear come up for older wills is the testator, which is what we used to call the will maker. And the other word for that is testatrix, which was traditionally a female signing a will. So those two terms can come up to describe the person that is signing the will, but if you're dealing with it in a modern context, it's always going to be referenced to the will maker. So the will maker has signed the will. In order for it to be valid, there has to be two witnesses. Now, the witnesses have to be adults. They cannot be receiving anything under the will, so they can't be getting a gift or other disposition of assets under the will. And they cannot be an undischarged bankrupt. So the easiest way, again, to deal with witnesses is that if you're dealing with a professional, then obviously two of my team are going to be witnessing your will with you. If you're witnessing the will out in the wild yourselves, then it's critical to make sure that your witnesses meet that criteria. And then they need to witness with you by signing the document. There's certain information that they need to provide about themselves in order to verify their identity. And then, although not a strict requirement of will signing, having each page of that will initialed or fully signed by the will maker and the two witnesses is also going to go a long way to ensuring the validity of the will. Now, the reason for that is that what the probate court is looking at when they're proving a will is that we have all of the pages, and also equally importantly, that no pages have been added later or taken out later. So one of the easiest ways for them to verify that is by having every page initialed or signed by all three persons that are meant to be signing. We also look at numbering pages. That's another way of mitigating that. But overall, we're wanting to make sure that that document is the complete document. Now, the other thing the court is looking at is let's call it the cleanliness of that document. So that document shouldn't be stapled or have staples removed and then restapled, shouldn't have paper clips, it shouldn't be folded, can't have coffee stains. All of these things are potential indicators that the document has been changed or tampered with after it was executed. So having a nice clean document is going to go a long way to ensuring that we're confident in the validity of that will. So if I was just to step back and summarize what I've just said, which is that we need the will maker to sign, we need the two witnesses to sign. And then as long as it's on paper or physically some other way written down, then you now have your valid will. Now, one of the things that comes up fairly regularly is, can't I just witness it electronically, or I'll sign it and my witnesses will sign it and we'll scan it back to you? Now, the reason that that's not appropriate for a will, and it is one of the very few documents that this is the case for, is that that document itself is your will. The version that's on my computer that I drafted is not your will. The version that I emailed to you that's unsigned is not your will. The version that you have printed out, signed with your witnesses, that is your will. And if that will is damaged or destroyed, then your will has been damaged or destroyed. So it's a document that is critical that that one copy is kept safe and unspoiled, basically. My recommendation is always to store your will with your trusted legal advisor. That could be your lawyer. You may also leave it with your accountant, but I don't think it's regular that accountants would hold wills. You can store it yourself at home. In my experience, often those become damaged or lost over time, and particularly when you pass away, it can be problematic if it's in your safe rather than at your lawyer's office. The other thing that I recommend is that when you are getting your will signed, that you attend with the person that drafted it for you and sign it with them and have it witnessed in that environment. Again, doing it in my office, I know that it's going to be witnessed correctly. If you do it yourselves, I said before, out in the wild, there is a possibility that it's not witnessed correctly, it's not signed correctly. And I know that that seems like a silly thing based on the limited rules or the limited requirements I've outlined for you, but you'd be surprised how often it comes back and there's a slight problem. And for the probate court, a slight problem can become a big problem. And at that time, you're no longer with us to remedy the problem because you already passed on. So it's a document that's really important to get right the first time, because if a problem arises, it might be too late. Now, in terms of some of the critical terms that we would like to see in a will, in conjunction with those basic requirements of it being in writing, it disposing of assets, the will maker signing, and there being two witnesses, what we really want to see is someone appointed as the executor, and then also the distribution of the entire estate. Now, firstly, in terms of the executor, that is the person or people that are going to administer the estate. They're not getting an entitlement to the assets. They are the ones that are going to collate everything, liquidate assets to cash if necessary, so sell houses, sell shares, that kind of thing, and then distribute out to the beneficiaries under the estate. So the executor's role is very important, and if they are not named in the will, or the executor is not available or is passed on, and there is no executor named, it is going to require a separate application to the courts in order to have someone appointed. So having your executor and probably a backup, critically important for the drafting of the will. And then the second point there around the distribution of the entire estate. Again, it's a critical element that's often overlooked. And what I mean by that is that it's all well and good to have specific gifts. I want to give the painting of Everest to my son. I want to give my ring to my other son, I want to give my tools to my daughter, whatever it is, those specific gifts, they're fantastic. There then needs to follow a distribution of the residue or the remainder of the estate. And that is a catch-all distribution to whoever you're wanting to receive the balance of your assets. So it might be I give this specific thing to this person, I give this specific thing to that person, and then whatever's left over, I distribute between my 3 children equally. And that catch-all is really important to make sure that no matter what assets are in your estate, the entire thing does have directions for distribution. Because if there's anything left over and your will hasn't dealt with it, then again, under the Administration Act, there's going to be separate provisions for how those assets get distributed, and it may not be what you would want to happen. So those 2 things are critically important. There's obviously a number of other provisions that we're going to turn our minds to when drafting wills, but for now, Simon says a valid will is a document that's been executed by the will maker in the presence of 2 witnesses that distributes assets and/or appoints a testamentary guardian. For more legal insights, check out our other episodes, subscribe to our channel to stay up to date with future videos, and remember, at LOA Law, we are good lawyers for good people.